ones that you cited?
That might be, but that has nothing, that doesn't talk to us about what you're suggesting in answer to Justice Thomas, which is that the plenary power is limited to dealing with tribes and not the treatment of individual members.
What I was talking about with Justice Thomas, Your Honor, is how the difference of a political classification and a racial classification. And our submission is that a classification is political when it regulates the tribe's sovereign interests, which is to say regulating the tribe as a polity. When it regulates Indian land, its treaty rights.
So you're saying, yes, they can't do only individuals if it has to do with the limited sovereignty question. Is that what you're saying?
As an equal protection matter.
Okay.
I
understand, John.
Justice Kagan?
I'm not sure I do, so I'm going to continue on the same vein. We have a long history of cases where we've understood legislation relating to the tribes as political in nature, not as racial. I think you have one case, which is Rice. And so I want to, on the one hand, say, what do you do with this long line of cases which has consistently said when you regulate the tribes, you're regulating political entities? And then on Rice, a very different situation. Number one, a 15th Amendment case not involved here, right to vote. But even more important than that, really the classification did not relate to a tribe. It related to some centuries-old affiliation with Native Hawaiians, which was much harder to understand as a current-day political entity. So I guess I think Rice doesn't do much for you, and then all these other cases really knock the legs out from this argument, and I'm wondering whether you would comment on that thought.
Sure. Let me start with Rice. I think Rice does explain that long line of cases that you refer to. It cites them, I think at page 519. It cites Moe, Fisher, Antelope. This is the line of cases that I think you're referring to. And these are cases that deal with tribes' sovereign interests in Indian lands, treaty rights. That's the fishing vessel case. The ability of Indians to govern themselves. That's Fisher. And its internal affairs. That is the line that Rice drew and how Rice understood Mankari, and the line that Mankari itself drew. This distinction that I'm drawing is rooted in Mankari itself, because Mankari says that it would be a much more difficult question if the hiring preference there extended to the whole of the federal government.
I mean, Mankari is such a different sort of case, right? Mankari is Indians are in a long list of other racial classifications. It was quite clear that that was the BIA one. Is that right?
Yes, that's correct.
Yeah. Okay. I'm sorry. I was I was mistaken. But I guess again, I'm sort of struggling with how different the classification in Rice was to the classifications here.
So I understand the question, Your Honor. Rice. This was, at the core of the Rice decision. Rice starts by assuming what it calls premises not established in our case law, both that Native Hawaiians should be treated as an Indian tribe, and further that Congress delegated to the state of Hawaii the power to regulate them. That the court assumed that they are an Indian tribe, that Hawaii had the power to regulate, and then it held that that Hawaii or Congress could not regulate a tribe in this way because it was regulating the affair of a state, not the tribe's own self-government. And I think the further point I would make about Rice is that Rice, the statute there had a much closer tie to self-government. It was the Office of Hawaiian Affairs. It had a much closer tie to self-government than the Indian Child Welfare Act.
Well, the first thing you need for self-government is, a functioning polity.
Polity, a form or process of civil government or constitution.
And Congress is very clear in this statute, that it thinks that this statute is critical to the continuing existence of the tribe as a political entity. And that's, in fact, one of the reasons it passes this statute, is the political entity is itself being threatened because of the way decisions on the placement of children are being made. So I guess I can't imagine a statute that's more wrapped up, given the terms and given what we know about what Congress was doing, is more wrapped up in the continued flourishment of political communities.
Your Honor, the placement preferences do not affect tribal membership. You can be a member of the tribe wherever you are placed. And it is, the fact that tribes often do unilaterally enroll children, regardless of where they are placed. The further point I would make, Your Honor, is that embedded in the question is a premise that tribes have a proprietary interest in these children, and I have to reject that premise.
Well, this is Congress's understanding of what it was doing. And again, this goes back to Justice Gorsuch's view of you can question the policy, you cannot question the policy, but the policy is for Congresses to make. And Congress understood these children's placement decisions as integral to the continued thriving of Indian communities. And Congress had a different view of the costs and benefits of how these decisions were being made. And that's not something that we can second guess, is it?
It is under the Constitution, Your Honor. The Congress does not have the power to treat these children as property of the tribes because of their ancestry.
We can second guess things under the Constitution if you have made a case about an equal protection violation or some other constitutional violation. But what I'm suggesting is that just the idea of standing up there and saying this has nothing to do with the continued thriving of Indian political communities, that's a judgment for Congress to make.
I want to be clear about this. There was a real problem that Congress was trying to address. We're not denying that the existence of a problem, but the means Congress chose are impermissible. Two wrongs do not make a right here.
Thank you, Mr. Micco.
Justice Gorsuch.
Counsel,
The Supreme Court case that could break Native American sovereignty. In the sprawling federal lawsuit HAALAND v. Brackeen, a handful of white foster parents, among other plaintiffs, are asking the Supreme Court to overturn a law called the Indian Child Welfare Act. ICWA, or ICWA, was created in 1978 to prevent family separation in Native communities. In June 2016, the Brackeens first welcomed a 9-month-old boy, identified in court records as ALM, as a foster child in their home. He was an infant who appeared scared and confused, Jennifer and Chad told the Post. But since the baby had a Navajo mother and a Cherokee father, state adoption officials told the couple he would likely be in their home for just months. The Brackeens then sought to formally adopt the loving and thriving boy in June 2017 after both of his biological parents' rights were terminated. The Texas couple obtained an emergency stay of the judge's order and proceeded to file the federal lawsuit, now being heard before the Supreme Court. Navajo Nation tribal officials later approved the adoption on January 8, 2018, a day to be celebrated for the Brackeens, they said. But the family's adoption saga took another turn in June 2018 when ALM's biological mother gave birth to his half-sister, identified in court documents as YRJ. Jennifer and Chad filed for custody, arguing that keeping the siblings together would be best for them. But the Navajo countered for custody to go to the girl's great-aunt who lived on a reservation. A Texas judge ruled the Brackeens would have primary custody, but needed to take the girl to the Navajo reservation for extended summer visits. A state appellate court later ordered a new trial when both sides appealed that ruling. The Brackeens insist the child welfare law intended to protect Native American children, including the now 4-year-old girl, is antiquated and fails to prioritize her best interests. According to scoutusblog.com, there are currently two main issues with Brackeen versus HAALAND. One, whether the Indian Child Welfare Act of 1978's placement preferences, which disfavored non-Indian adoptive families in child placement proceedings involving an, quote, Indian child, end quote, and thereby disadvantage those children, discriminate on the basis of race in violation of the U.S. Constitution, and two, whether ICWA's placement preferences exceed Congress's Article 1 authority by invading the arena of child placement, the, quote, virtually exclusive province of the states, end quote, as stated in Sosna versus Iowa, and otherwise commandeering state courts and state agencies to carry out a federal child placement program. Regarding the 14th Amendment, it states equal protection in race. Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. The 14th Amendment is one of a series of constitutional provisions having a common purpose, namely securing to a race recently emancipated, a race that through many generations had been held in slavery. This would later be solidified in the Civil Rights Act of 1964. The passage of the Civil Rights Act of 1964 marked a milestone in the long struggle to extend civil, political, and legal rights and protections to African Americans, including former slaves and their descendants. This law outlaws discrimination based on race, color, religion, sex, and national origin. Overview of race-based classifications. When the government legislates or acts on the basis of a, quote, suspect, end quote, classification, the court sets aside the traditional standard of equal protection review and exercises a heightened standard of review referred to as strict scrutiny. Paradigmatic, serving as a typical example of something categories, is classification by race. Under the strict scrutiny standard, the government must demonstrate a compelling interest. Usually little or no presumption favoring the classification is to be expected from courts. In addition, the government must demonstrate that its use or reliance on a racial classification is narrowly tailored to further that compelling interest. Both prongs of the court's district scrutiny standard involve the case-by-case basis analysis of multiple factors. Before settling on strict scrutiny for evaluating racial classifications for equal protection purposes, the Supreme Court's jurisprudence on racial classifications went through significant change over the years. In its 1944 decision, Korematsu v. United States, for example, the court adjudicated the wartime forced removal of Japanese Americans from the West Coast. In that case, the court said that because government action targeted only a single ethnic racial group, it was immediately suspect and subject to rigid scrutiny. So to give further context to this case, the matter originally came up in a Texas district court on an adoption petition filed by Chad and Jennifer Brackeen. After their effort was challenged by the Navajo tribe, the Brackeens brought suit in the U.S. District Court in Fort Worth. The Cherokee Nation, Oneida Nation, Quanut Indian Nation, and Morongo Band of Mission Indians intervened in the case. The U.S. District Court declared that the ICWA was unconstitutional and the case was appealed. The Fifth Circuit Court of Appeals reversed the District Court in a panel opinion. The full court on rehearing the case in Bach. In law, an en banc session, pronounced French for en bench, also known as en banc, en banco, or en banc, is a session in which a case is heard before all the judges of a court before the entire bench, rather than by one judge or a smaller panel of judges. En banc review is usually for unusually complex or important cases or when the court feels there is a particular significant issue at stake. Held that parts of the law that set federal standards for lower and state courts were constitutional, but that the parts of the law that required state agencies to perform certain acts were unconstitutional as a violation of the 10th Amendment. The Supreme Court heard the case on November 9th, 2022, and a decision is expected in spring 2023. So the legal challenge. In October 2018, Federal District Court Judge Reed O'Connor struck down parts of the law as unconstitutional, claiming that it mandated racial preference. In December 2018, the United States Court of Appeals for the Fifth Circuit ordered that O'Connor's judgment be stayed, holding that it violated tribal sovereignty. On August 9th, 2019, the court ruled that the law does not violate equal protection. On November 7, 2019, the court voted to rehear the case in Bach. The equal remains in effect. How does the United States define indigenous peoples / American Indians? The United States Constitution, more than 300 treaties, and over 2 centuries of federal law recognize Indian tribes as domestic dependent nations with degrees of sovereignty existing within the confines of the United States. The U.S. Census defines American Indian or Alaska Native as, quote, a person having origins in any of the original peoples of North and South America, including Central America, and who maintains tribal affiliation or community attachment, end quote. Individual American Indians are, by legal definition, citizens of their federally recognized tribal nations, the United States, and the state in which they are domiciled. Tribal membership is a political designation, not a racial one. That is to say, merely having an ancestor who is an American Indian is not sufficient to make someone a member or citizen of an American Indian tribe. Accordingly, it is inaccurate to identify American Indians solely as, quote, racial minorities, end quote, even though ancestry and kin relations are core features of American Indian tribal membership. So what does this have to do with those who descend from U.S. chattel slavery? Regarding federal and state reparations in HAALAND versus Brackeen, 1. Any preference based on race could be considered unconstitutional, and 2. Tribes' political status and relationship is currently constitutional with the United States. However, if the Supreme Court sees the adoption case follows outside the guidelines of equal protection, meaning the non-Indian parents were denied their civil rights, this could potentially change the dynamic of the case for reparations. Or does it? Let us know what you think. Write down below at the comments, or you can send us an email at atmmediagroup@gmail.com. Please like, share, and subscribe, and hit that bell.